India follows a system where personal matters like marriage, divorce, inheritance, and adoption are often governed by religion based personal laws. The idea of a uniform civil code under Article 44 aims to bring common civil laws for all citizens. Recently, Uttarakhand enacted its own uniform civil code and other states may follow. But what happens if two states pass UCC laws with different rules, say on live in relationships? In a federal country with a written constitution, such conflict is not settled by emotion but by constitutional design. The issue of conflicting state level uniform civil codes, especially on matters such as live in relationships, raises a constitutional question of repugnancy. Repugnancy means inconsistency between two laws dealing with the same subject. The governing constitutional provision is Article 254 of the Constitution of India. To understand this, one must see where marriage, divorce, and related civil matters fall in the 7th schedule. These subjects are listed in the concurrent list, that is, List 3. Both Parliament and state legislatures have the power to make laws on concurrent list subjects. However, this shared power can create legal conflict. Article 254(1) clearly states that if a state law is inconsistent with a law made by Parliament on a concurrent list subject, the parliamentary law will prevail and the state law will be void to the extent of inconsistency. But the Constitution also provides flexibility. Under Article 254(2), if a state law on a concurrent subject is inconsistent with an earlier parliamentary law, it can still prevail within the state provided it has received the assent of the President. This is an important federal safeguard. However, Parliament retains the power to override such state law later. Now consider the specific scenario. If multiple states pass UCC laws with different provisions on live-in relationships, the conflict between state laws themselves is not directly resolved by Article 254 unless there is a parliamentary law in the same field. If Parliament has enacted a national UCC or a law governing live-in relationships, then Article 254 will determine validity. If there is no parliamentary law, states can have variations. India already tolerates such diversity, for example, in land laws and police laws. However, if two states' UCCs conflict in practical operation, courts will examine legislative competence under Articles 245 and 246 and apply principles of territorial jurisdiction. A state law operates only within its territory. Therefore, interstate conflict becomes relevant mainly when rights or disputes cross state boundaries. Judicial precedents such as M. Karunanidhi vs. Union of India have clarified that repugnancy arises only when both laws occupy the same field and are directly inconsistent. Therefore, the constitutional article governing repugnancy in this context is Article 254 read with Articles 246 and the concurrent list. In conclusion, India's constitutional design allows diversity within unity. State UCC variants are possible, but where inconsistency arises with parliamentary law, Article 254 ensures supremacy of national legislation while preserving limited state autonomy. This balance reflects cooperative federalism, not legislative chaos.